We'll do administrative law today. Okay. First, we'll start with administrative law, and then after completing it, we'll discuss some questions, unit 1 or unit 2. Okay. सर इसका वो काम नहीं कर रहा, जूम आउट, क्योंकि वो भी अगर खोलो ना, उसे अगर मैं एज पे भी खोल रहा हूँ तब भी खोलने में दिक्कत कर रहा है. बता दो. कीड़ा हो रहा था. ठीक, थैंक्स सर. You can see. Uh, Let me briefly explain you what administrative law means. Two things you need to understand. This I have not written. You might write all of this. That there are two kinds of systems of law. Okay. First is the common law system. First is the what is this mess?
You are currently the only person in this conference.
Oh yeah. अरे ये बंदा पब्लिक एडमिनिस्ट्रेशन का है भी नहीं, सोशियोलॉजी था इसका ऑप्शन। अरे एक सेकंड लाइव। Now understand the difference that there are two kind of law systems. One is the common law countries. Okay, common law countries like India, UK. So these are common law countries. Why these are called common law countries? Because these countries' laws are not different for different individuals. There is one law, constitution applies to everybody. Any law there is, it applies to everybody. There is no different set of laws for government servants and normal citizens. You understand? There are no different laws. Same laws applies to you also, a government servant also, a police officer also, everything applies to them. Everything applies to everybody, and this common law system, that is why it is called common law. Common law countries are UK, India, these are common law countries. In countries such as France, in France, what happens is they have a different set of laws for their administrative or public officials. For them, the law is completely different. Law is completely different because the functions they do, the public functions they do, to carry out those functions, they require some form of authority. And while they are carrying out these functions, and they are carrying out these functions to, for example, implement some laws, they require some forms of power. To keep a check on these powers, there is a specific set of laws that were developed in these countries. That is where the idea of administrative law comes from. That means normal citizens have a different law. The people who work in administration, in the government administration, there is a different set of laws that regulate their day-to-day administrative affairs. Are you able to understand? That means a different regulation for administration, a different regulation for normal citizens. Okay? Two sets of laws are there in countries such as France. It's called droit administrative. Okay? And common law countries, you know, one a particular law for everybody. Now, in this conceptually you understand. Okay. Now, what is administrative law and why are we studying administrative law under public administration? Administrative law is essentially it's basically a set of law that regulates government activity. Now, that regulation can be by a specific set of different provisions, like France did, or that regulation can be what? Through the idea of constitutionalism. through the idea of, so for example, if we have seen certain writs are there. So courts regulate administrative activity. If the public servant is not acting, court will go ahead and instruct the public servant to act. These regulations or these limitations and checks to the power of the administration, this study is called administrative law. Okay? So in India, what all do you think constitute administrative law? What all things might constitute? Something that regulates the administrative activities, the day-to-day authority of the administration. In some form, but some very greater laws, such a think of something that actually limits the power of the administration. It keeps a checks on the power of the administration. लॉ कौन सा लॉ है ऐसा? लॉ या कोई बॉडी, वो क्या है जो लिमिट करता है एडमिनिस्ट्रेशन का पावर? Yes, constitution. That is the first point. That constitution regulates activity of the state. Part 3 of the constitution, the fundamental rights, they safeguard the citizen from the power of the state. That is the first principle under fundamental under administrative law. Under administrative law, it says that what all things actually regulate or stop the government or limit the power of the administration, so that their discretionary power is being exercised not arbitrarily but according to the due process of law or rule of law. So the second part that we understand here is administrative law is about rule of law. So we need to find out what exactly in our country is there that ensures rule of law. Yes, judicial review, correct, Ravi, correct. We need to ensure what ensures rule of law in this country. Rule of law means what? Law is supreme. No administrative body or political body is supreme. Law is supreme. And according to that law, people have to work. So, as he said, judicial review is an essential element, and whatever the administration is doing has to be reviewed, has to be judicially reviewed. Okay. So, this was this. Then comes a rule of law. Let's read whatever I've written. So you understand it till here, that it is something that is limiting and regulating the activities of the state. There are certain definitions I have given. You just memorize those definitions, important definitions. Administrative law is a branch of public law that governs the activities of the executive branch of the government. What kind of executive? Permanent executive. Yes. Its primary purpose is to ensure that administrative authorities act fairly within their legal limits and to protect the common citizenry from any abuse of power. So any abuse of power is limited how? Through fundamental rights, through Article 32. So that also ensures administrative law in the country. Anything that ensures rule of law is part of administrative law. And to protect the from abuse of power, it is not a codified law. It is not codified in India. Okay, this is administrative law. It is basically a judge-made law. So judicial review is the very core element of administrative law, because people have rights against the government and they can go to the courts to enforce this. This is the power of judicial review. That is why it is considered the basic structure of the constitution. Okay? Judge-made law that has evolved over time to deal with the complexities of modern welfare state. Why is administration given so much power? Why do they have so many functions within them? They're line agencies to carry out what? Policy, welfare functions, right? So whenever we studied that under welfare state was very bloated in nature. Okay? State was very bloated in nature. This led to uh, what do you call that? Lot of powers and authority was within the state. Lot of functions was within the state. Now, state is such a huge entity. How do you regulate the state? Through this mechanism, administrative law. Okay. Now, administrative law determines the organization, powers, and duties of administrative authorities and includes laws relating to rule making power of the executive. That means delegated legislation. We'll study in detail delegated legislation. Certain quasi judicial function. So you understand how executive makes laws, that parliament or the legislative assembly, they create a skeletal structure of law. For example, Environmental Protection Act, but daily circulars, orders that I discussed yesterday, I believe. Those things are very much within the what do you say? Delegated legislation, they are very much within the function of the executive, that they fill in the gaps wherever the law lacks. Day-to-day activity they do. So when it comes to delegated legislation means the legislative powers, the legislature has delegated it to the executive, and executive makes laws every day for everyday functioning. Okay, but the power is coming from where? Where is the power coming from? Legislature only. So the source of power is the legislature. That is why it is called delegated legislation. That is a delegation, that is temporary giving of power. Then quasi judicial functions. For example, administration does quasi judicial functions. When we say district magistrate, now what does the district magistrate do? They have some magisterial powers to decide whether something is right or wrong. That is the work of a district magistrate. So district magistrate says that whether a revenue function or a collection of land revenue has been done correctly or not. There are some courts, certain labor courts, in which the district magistrate sits as a adjudicatory authority. So these are what? Quasi judicial functions. That he is not exactly a judge, but he sits in these rules. So these functions. Similarly, there are tribunals. There are central administrative tribunals, national green tribunals. There are tribunals for every small regulatory function that takes place. So these tribunalization is an issue under administrative law. We'll study that. So these tribunals, their quasi-judicial functions are carried out. Okay, that also falls under administrative law. Then legal liability of public authority, of course, that will fall under administrative law. Judicial review of administrative actions, of course, obviously it is administrative law. Now, there are certain definitions you need to keep in mind. Casey Davis, he says administrative law is the law concerning the powers and procedures of administrative agencies, including especially the law governing judicial review of administrative action. Why is judicial review? Because administrative law in India is somewhat of a judge-made law. Yes, so that is why judicial review is important. Professor Wade will say administrative is the law relating to the control of government powers. That how we can control the power of the government, not so that it does not become arbitrary in nature. Control over government powers. A.V. Dicey will say, basically, I'll remove Dicey's here because Dicey was very much against administrative law. He says there is nothing called administrative law. I.P. Massey, he's a scholar of law. Basically, he says administrative law deals with the organization and powers of administrative and quasi-administrative agencies and prescribes rules by which official action is reached and reviewed in relation to individual liberty. Basically, to protect individual and individual's liberty, from the actions of the state, administrative law stands in between to regulate and ensure that no arbitrary action happens. Understood? Then comes nature, scope, and objectives of administrative law. Nature of administrative law. Administrative law is a new branch of law that has emerged to reconcile with the needs of a progressive social welfare state with the rights of individual citizens. Its main objective is to keep administrative authority within their limits so that their discretionary power does not turn into arbitrary power. Very easy, self-explanatory. So basically, because welfare state has progressed since the last 100 years, administrative law is that emerging field because we need to regulate the actions of the government. What is the objective of administrative law? To control government power and to ensure they are effectively used. Provide remedies to persons who are aggrieved by the government actions. To maintain the rule of law and to improve the performance of administration. How does it improve the performance of administration? Making them accountable. Yes. Making them accountable to what? To the rule of law. Very easy. Now, what is the scope? That means how wide is administrative law? Where do we study administrative law? Basically, the structure and power of administrative bodies are studied. That these are administrative bodies, their structure and power are studied under administrative law. Secondly, delegated legislation is studied. That means rule making power of the executive is studied. Similarly, administrative adjudication. So the quasi judicial functions of the administration, when they are deciding to do something or not, it's called it's also the scope of administrative law. And finally, control mechanisms and remedies like writs and judicial review. Whenever courts step in and see that whether the administration is working well or not, they instruct the administration to do something. It's called what? It's a part of administrative law. Okay? Then principles of natural justice. That whatever the administration is doing, it should follow the principles of natural justice. The principles we'll discuss today only, the issues in the principles. Now, sources. In India, administrative law is part of the ordinary law of the land, and it's ordinary law of the land. You understand? It's common law. That it is the law is same for us also, the policeman also, the administrator also. It's same for everybody. Now, what is the sources? First source is the Constitution of India, and its part 3 is very important. Constitution of India and part 3. Why, you understand? Because it is the fundamental law in which everything is governed in India. Any administrative action, any legislative action, any executive action, it has to be in line with the constitutional principles, or else that act will be considered unconstitutional and hence null and void. Understood? Similarly, there are statutes. Acts passed by parliament and state legislature are the principal source of administrative power. Any acts that are passed, for example, what acts recently was passed? National sports policy. So that is also form a part of the power of the administration to carry out certain activities in the field of sports. Yes. Ordinances, similar to statutes, basically brought by the governor or the president. Delegated legislation, rules and regulations made by executive under the authority of a statute. So delegated legislation, you understand by now that the law making power is given to the executive to carry out certain activities, day-to-day function. And cases, High Court and Supreme Court cases, these are taken as the source of administrative law. If the Supreme Court has said that you have to function in this particular way, you have to function in that particular way. There is no other way. Now, why did administrative law grew in the 20th century? Why did it not grow in the 19th or the 18th century? Why not in 21st century? Why 20th century? What was so different? First, was the concept of welfare state. We wanted the state to carry out certain welfare functions for the citizens of India. Yes. Second, see, the shift from laissez-faire police state to welfare state massively increased the functions of the government. Don't you think? State now will provide employment. State will provide basic education, healthcare. Uh, what other functions? Military functions are of course there. There are certain regulatory functions, law and order functions. So certain things such as Factories Act, Minimum Wages Act. That means state is growing. You need larger role of the state. Similarly, inadequacy of legislature. Parliament lacks the time and technical expertise to legislate on every detail of modern governance. This led to the growth of delegated legislation. This led to the growth of delegated legislation. Inefficiency of judiciary. Day to day, so this means tribunalization of justice. This is an issue we'll study only. Something called tribunalization of justice. Whatever I am showing you today, I'll give you some extra notes apart from this, so as to on these issues, so that you can directly put them in your answers. Because for explanation and for class, this is fine. This I made it for myself only, not you guys. For you, I'll put in some extra things. Same conceptually, it's the same, but you will have extra material to write, extra case studies, certain certain case laws, so that you can write your answers. Inefficiency of judiciary. Now, judiciary, you see that there are a lot of sectors. For example, there are sectors such as IPR, intellectual property. There are sectors which are construction related. In these sectors, what is happening is they are very technical in nature. Very technical in nature, and courts do not have so much time to get into every detail. And the requirement is a person has to go into the detail to actually understand what the matter is. It's not any normal matter, it's a very heavy matter when it comes to especially infrastructural cases. Lots and lots of pages of documents, communications, etc. Might have happened. To do this, or to take care of these activities, certain tribunals will found. Okay? Tribunals, administrative tribunals that were there, who are expert bodies in a particular sector to take care of things. For example, National Green Tribunal. Now, the courts do not have so much time, and they're already filled with so many cases. So, if there is certain environmental related cases, now you need certain technical experts to explain those things, right? The judge alone can't just see and understand everything. Okay? So there are different forms of environmental pollution. It's a very technical field. So for that, you have National Green Tribunal. There are experts, etc., sitting, and so these are what? Tribunals. These are not courts. These are tribunals. They are different from the court system. So tribunalization of justice is a function of administrative law, that everyday action of administration goes to be reviewed somewhere. It goes to these tribunals. Understood? Need for preventive measures. Unlike courts, administrative authorities can take preventive measures. Example, food safety inspection, which often is more effective than punishing a breach after it has occurred. So these are the reasons why we started something called administrative law, or it emerged eventually. Now there are certain principles that you need to keep in mind. First is judicial review. Now what is judicial review? What it simply means? Basically checking, or reviewing a particular law, and to ensure that that particular law is constitutional or not. It also relates to certain administrative actions as well, whether some action they have done, is it constitutional or not. If it is not, it is declared null and void and things are struck down. That is judicial review. Why it is important in administrative law? Because that is the source of administrative law. because we don't have a separate law for administration. Okay. For example, court in a case says that administration cannot go ahead and do A. Now the administration forever from now on won't go ahead and do that action A. Well, this is essentially administrative law. That judicial review through a case law, they have put in administrative law. Understood? Rule of law. Rule of law is a principle that rule of law or law is supreme. There is nothing above than that, and that is has to be ensured in the what do you say? It has to be ensured in administrative function. Next principle is separation of power. This is very important to the idea of constitutionalism. That means limitation on government power. It prescribes the allocation of distinct power to legislature, executive, and judiciary to create a system of checks and balances. Now, yes, Rabe, action of the government is reviewed. Now, the legislature, don't you think legislature checks what administration does? Yes, because executive is what do you say, responsible to the legislature. So they are answerable to every act administration is doing. Yes. So legislature also keeps a check on it. So administrative law also sees when legislature keeps a check on administration. Principle of natural justice. Now there are two core maxims under principle of natural justice. You don't have to remember these Latin words. You just have to understand that nobody can be a judge in their own cases. For example, I file a complaint against you, and you are the judge of that, whether you have done wrong or not. Isn't this very weird? Similarly, do you think only the judge should only hear one side and give the judgment? No, both sides needs to be here. That is natural justice. Basically, your natural understanding of things. That's natural justice. Two major principles: that a person cannot be judge of their own case. Second, you have to hear both sides before deciding. As simple as that. So that is the principles in which administrative law should follow. There is something, a doctrine called doctrine of reasonableness. Discretionary power must be logical. You shouldn't give discretionary power on your own. It has to have the backing of reason. It should be reasonable. For example, to carry out 100 tasks, you need 100 power, 100 authority. Okay, you shouldn't make this 500 authority for only 100 tasks. That means it should be proportional in nature. It should be reasonableness. Then there is accountability. Decision maker must be answerable for their actions, either politically or legally. That means they are answerable to the political executive, whatever administration is doing, and they are answerable to the courts. That means there are dual checks and balances on them. Are you able to see? And there is other checks and balance because those political executive are answerable to the legislature. Basically, three institutions you are answerable to. Simple. Now let's see. What is the mechanism in which administrative law is carried out? It is the control over administrative action. Okay? First, what all constitute administrative action? Or what all actions do administration has? There are quasi-legislative action, that means delegated legislation. So if there are, CBSE is framing rules for conducting certain examinations. Okay. In the framing of those rules, CBSE says that children are allowed to take mobile phones. Do you think that is constitutional in nature? No, right? It's a ridiculous law. Now, CBSE has the power to make laws or to frame rules to carry out these activities. But do you think it is constitutional? So don't you think CBSE will be held liable in front of court? Basically, this is administrative law. These are quasi-judicial functions. Quasi-legislative functions. These are delegated legislation that is given to them. Then quasi-judicial functions. Now, what are these quasi-judicial functions. For example, you are DC of a district. Okay. Now somebody comes for some licensing, that they want to start this particular venture in this district. They are there to take some licensing from you. Now you see and you reject it without applying your mind. Don't you think this should be reviewable by court, that whether this person has given this in a right frame of mind or not? Has that person applied actually law or not? Or has the person, according to their whims and fancies, rejected it? Okay, I don't like you, so I won't give you a license. This is reviewable by the judiciary. Quasi-judicial actions. The power to perform acts that are administrative in character but require judicial traditions, like weighing evidence, hearing parties, etc., etc. Then comes purely administrative actions. The residuary action that is neither legislative nor judicial. For example, the functions of selection committee or transfer of a government employee. See, this particular case law, A.K. Kripak versus Union of India. Now, for example, appointment. Who to appoint if they want to transfer somebody or to appoint people? There is a committee that is an appointment committee. That, for example, these are the people who will appoint in these particular functions. So that is an administrative function, but that is reviewable by court. Why? Because rule of law needs to be applied there also. If you have been given a discretion to choose people, you can't choose people on the basis of you want. Constitutional principles need to follow. You can't say, okay, this person is from my caste or my religion, I'll take him. No, you can't do that. That means those functions are also administratively reviewable. Okay? And there are ministerial actions. An action taken as a matter of duty imposed by law with no discretion or judgment involved. Example, collection of revenue as part of prescribed tax rates. Now you go ahead and collect certain taxes, okay, from a business. Now you have not decided the tax rate. Government has decided. Whatever you are, you go there and collect it. Even those actions are reviewable. Those administrative actions are reviewable. Whether you have gone in a particular right time or not. Have you barged into the house of that individual? All of these things are seen. Okay. So these are the kinds of administrative functions that are administratively reviewable. Now, how does judiciary control the administration? Similar things that we studied in accountability and control. Habeas corpus is used, mandamus is used, that the judiciary commands the public authority to carry out certain functions. Prohibition is used, that they stop the particular court or a particular quasi-judicial body from acting, a tribunal from acting or hearing a law, because that is not their jurisdiction. Similarly, certiorari. That means to quash a illegal judgment given by the administrative tribunal. Okay. Then quo warranto issue, that by what authority this particular public person has done this particular thing. See, these cases, I'll give some other cases to you in your notes. I'll put in, and I'll put the details also, so you go through it. Conceptually, this is the thing, and that A.K. Kripak case is a very important case. I'll put the details of those cases in your notes. You go through it while writing answers. You can put those into it. Parliamentary control. So control over delegated legislation. How do you control delegated legislation of individuals. How do you control the delegated legislation given to the executive? So first, Parliament controls it. Yes. How does the Parliament controls it? Basically, they lay down the procedure. Rules made by executive are required to be laid before the Parliament. So executive has made a particular law, it has to be laid before the Parliament. The way ordinance is laid before the Parliament. Yes. This can be simple laying, negative laying, or affirmative laying. Or see, ignore this. There is a committee in Parliament called the Committee of Subordinate Legislation. So this committee is a standing committee. They year long they keep seeing that whether or not this particular whatever the administration is doing, whatever new laws they are passing, whether they are tenable or not, whether they are constitutional or not. Then there is something called procedural control. The Parent Act itself may prescribe procedures like prior consultation and pre-publication of rules which the executive must follow. That the legislature or the parliament might say, if you have to make a particular rule, you'll have to follow this procedure. These 10 steps you need to follow. This is also control over delegated legislation. Don't you think? They are controlling the procedure. Then there is judicial control. Anything that the administration is doing, any law they are making, it goes to the law, goes to the courts. You can yourself can go ahead and challenge it in court and get it struck down. So judicial review is the basic idea. Next we study administrative tribunals in India. Why did they grow? First, to provide cheap, speedy, and expert justice and to reduce the burden of ordinary court systems. First was that. So, what are the key features of that? They are a mixture of judicial and administrative bodies. In NGT, you will see retired High Court judge, retired Supreme Court judge will also sit. Okay? Similarly, required to act judicially but are not bound by rigid procedure. So they are not bound by rigid procedures such as CPC or CRPC. They are not bound by that. They are simply bound by principles of natural justice. That is the only thing. They must observe the principles of natural justice. Understood? There is CAT, NGT, Income Tax Appellate Tribunal. So Income Tax Appellate Tribunal, that means senior bureaucrats will sit there. Income Tax Appellate Tribunal. Now, the acts of these tribunals, any judgment they give, these judgments will be is judicially reviewable. And this was held in L. Chandrakumar versus New York of India. It says that judicial review is a basic structure of the constitution, and even if these are administrative quasi-judicial bodies, they are giving certain judgments, they are open to review by the Supreme Court and the High Court. Okay, so High Court has the first right to review those things. So first appeal from these administrative tribunals lie directly to the High Court. Okay. In some matters, it lays directly to the Supreme Court also. Okay. So it differs. Now, administrative discretion. What is this discretion that the administration is exercising? This discretion is given. Why? Why is this discretion given to the administration? Welfare state to carry out some welfare functions. So discretion is the power given to an administrative authority to choose between alternative course of actions. For example, there are two options for you how to implement this. Option A, option B. So there is a discretion for you to choose whether to choose A or B. It is up to you. But the reason for choosing them should be constitutional in nature. Okay. It is essential for a welfare state to respond to complex and unforeseen situations. However, absolute discretion can become arbitrary in nature. Okay. Uh, Now, when choosing those two options, option A or option B, the judiciary won't go into that why did you choose A over B. Basically, they'll only see that the reasoning behind choosing A over B should be constitutional in nature. That is it. So discretionary power is discretionary, but it is has to be that discretion has to be exercised in a constitutional manner. Constitutional principles must be followed. So abuse of discretion or malafide. So when power is exercised with a bad intention for a dishonest purpose, it is used by the governor or the president to carry out certain activities that are through bad intentions. They're carrying out to, what do you say, maneuver away from a rule of law. So these are malified laws, and judiciary has the power to check it. Secondly, key grounds for judicial control: one is malified intention, second is improper purpose. So whatever purpose some power and discretion is given, if you go ahead and use it in some other way, that means you are not using it for the purpose. So judiciary can review it. These are the grounds. Irrelevant consideration: when the decision is based on factors that are not relevant to the purpose of the act. For example, the governor goes ahead and says president rule will be imposed here. Why? He says that I mean he did not like the chief minister. This thing can't happen. So irrelevant reasoning can't be given. It has to be regarding the purpose or certain procedures that the constitution has laid down. And finally, unreasonableness. Nothing can be arbitrary in nature. For example, see this example: Air India versus Nargis Mirza. Now, during this time, Air India was a government PSU. So, because that air hostess, when that air hostess became pregnant, Air India terminated her employment. Now, the court said you cannot discriminate people or women on the basis of somebody who has been pregnant or who has never been pregnant. So this is a very problematic notion that you are following. So, Supreme Court reversed the judgment of those of Air India, which was what a PSU of that time, which was state under Article 12. These actions are administratively reviewable, which are reviewable by the judiciary because it's very unreasonable in nature. Under this topic, we'll also study this ombudsman, Lokpal, and Lokayukta. These are institutions where the what do you say, citizens can go ahead and complain against. You can go ahead and complain against the administration, whatever problems you have with the administration problems, you can go ahead and complain. And while doing that, you can, get certain remedies from Lokayukta directly. If the administration is doing corruption, you know that you can go ahead and complain to the Lokayukta. Okay. So this ombudsman started in Sweden in 1809. Imagine how forward looking these people are. Okay? पढ़ेंगे ना वही वाला पढ़ेंगे अभी, ठीक है. लोकपाल एंड लोकायुक्त एक्ट 2013, ठीक है, अन्ना हजारे ने जो प्रोटेस्ट किया था तभी आया था ये चीज. So passed after the massive anti-corruption movement led by Anna Hazare, Lokpal is a multi-member body that inquires into allegations of corruption against public functionaries, including the Prime Minister. So jitne bhi sab, all public officials that are there, if you say that somebody is corrupt, you can go ahead and complain to the Lokayukt or to the Lokpal. Okay? Lokayukt is many states, starting with Maharashtra, have established the institution of Lokayukt. There are significant structural variation among states. Basically, they act as Lokpals only, but at the state level. Okay? Now, appointment jurisdiction. See, their recommendations are generally advisory in nature. For example, they'll recommend something to the law enforcement. The law enforcement, it is not mandatory for the law enforcement to follow whatever they have recommended. Law enforcement can only use them as certain recommendation and evidences. They are not mandatory in nature. So whatever, if the Lokayukt finds that the particular minister, cabinet minister, is involved in corruption, okay, it shows these evidences. Those things are not mandatory. They are recommendation in nature to the what do you say, law enforcement agencies. Now, what all other accountability mechanisms are there? RTI is there, CVC is there. Yesterday we read, right? So you can see how administrative law and those accountability and control measures are very same. To ensure accountable administrative law, those measures, accountability and control measures are implemented. Now, here questions will actually come, and I'll give you some much more. I'll put some other things in your notes also. Here the questions will come. Conceptually, you understand what exactly administrative law is. Very simple, straightforward. Tribunalization of justice. Now, this is a direct question that is asked. Tribunalization of justice. Whenever too many tribunals are created, for every different sector there is a tribunal. Some problem with administrative body, go to Central Administrative Tribunal. Any problem with environment, go to National Green Tribunal. So the problem is when you tribunalize it, when you are tribunalizing justice, you are giving more power to the administrative authority to decide whether something is right or not the judicial authority. So this is somewhat creating a problem of those checks and balances. So administration is committing something and the senior administrator is judging something. That means the problem of internal accountability is coming. This is something that Henrik Feiner will not agree with. Yes. There are growing concerns that government is creating too many tribunals, taking away the traditional jurisdiction of high courts and vesting it in bodies that are not truly independent of the executive. Basically, the executive is involved in deciding whether the permanent executive has done things correctly or not. That's a problem. So it's like moving away from the principle of natural justice that says a person should not be the judge of his own case. Here, the administration is the judge of the action of the administration. That is why it's a problem. The problem with this is erosion of judicial independence. So these members, tribunal members, are not all of them are not judicial members. They are also expert members that are there. Bypassing the judiciary. This goes away from the judiciary. There is lack of uniformity because these tribunals, they don't function according to certain procedural laws. They function according to natural justice. So that means there is no uniformity of the conduct they are conducting, anything that they are conducting. I'll add in some extra examples for you. Don't worry. In your notes, I'll put it. Basically, now we understand what is the problem when it comes to tribunalization of justice. Now, how much can the legislature delegate to the executive? If the legislature would want, can they delegate everything to the executive? No, right? What is the point of legislature there? That means there is something called doctrine of essential legislative function, that some functions only legislature can do. Things such as taxation, imposition of a tax. Now, imposition of a tax can only be done by the legislature. Executive can't think of today that okay, we'll impose a new tax. No, you'll have to be through legislature. So, doctrine of essential legislative function, saying what essentially can be delegated and what cannot be delegated. The core constitutional principle is that legislature cannot delegate its essential legislative functions. What are these essential legislative functions? To make a policy decision, whether to do something or not. Such as, for example, things such as uh, Digital Data Protection Act. Okay? So that means that's a policy decision. Legislature takes a policy decision. Within those policy decisions, executive can make laws, repeal and amend an existing law. For example, there is a particular law, Income Tax Act is there. The government can't think today, okay, this particular laws, this particular section won't apply. The government can't do that. Either the judiciary does that or the legislature does that. Executive cannot do that. Similarly, imposition of a tax, you have understood, give retrospective effect to a law. What does that mean? Retrospective effect to a law. Yes. Retrospective effect to a law. Basically, the past actions cannot be brought under the present law. All application are prospective. If a law is made today, it will be applicable from today onwards. The old actions that have been done, that cannot be brought under a present law. So, this executive cannot do, only legislature can do. That means retrospective effect can be given to a law. Only legislature can do, executive can't. The legislature can delegate the power to fill in the details to implement the policy that is already laid down. This is known as subordinate legislation. For example, a larger piece of skeletal law is made. Okay, the legislature has brought that these will be the policy. The executive can only fill in the details. Okay, this is how we'll implement it. This is how we'll implement it. This is these things. Doing these things is called subordinate legislation. Okay. Now, when it comes to rule of law, what exactly is a rule of law? A.V. Dicey is himself was against administrative law, but rule of law is very important in the concept of administrative law. So A.V. Dicey gave that there are three important elements in rule of law. You should know because this is an issue. First is supremacy of law. That law is supreme, there is nothing above law. Equality before law. That means there are certain, before law, people has to be equal. That means common law. Everybody, an administrator, a normal citizen, a prime minister, everybody is common before the law. There is no separate law like the Droit administrative system of France. There is nothing like that. So common law. Then primacy of the rights of individual. Constitution is the result of right of individuals as defined and enforced by the courts, not the source of their rights. Basically, Constitution is not the source of rights of individual. A very important thing. Constitution, if Constitution is removed, that does not mean fundamental rights of people go away. Rights of individual are inherent in human nature, human existence. And Constitution is a byproduct of that. Constitution is not the source of rights. Constitution is the byproduct of a particular system in a society that ensures the rights of individuals are there. Are you able to understand? Dicey will be criticized. Okay, Ivor Jennings will criticize, argue that Dicey's equality before law was a myth. Ivor Jennings will say the governor or certain public functionaries are given so many immunities, things such as AFSPA. When AFSPA is applied to a particular province, that means security personnel in those provinces have a lot of powers. Okay, so essentially, Ivor Jennings is saying that whatever E.V. Dicey said about equality before law, it does not apply in real life. In reality, things are very much different. And it is not compatible with welfare state. Welfare state requires a massive increase in administrative discretion. You can't treat that it applies to everybody equally. That means the discretion needs to be followed. In India, this rule of law is part of the basic structure doctrine, that means which cannot be amended, and this is given under Keshwananda Bharati case. So, rule of law in India is essentially a basic structure. So that is why inherently there is no uh, particular law that says that this is administrative law of India. That means what is essentially there is in India are these judgments and the constitution. That is administrative law in India. Okay? Principles of natural justice. Odi alternate partum, you have understood? That other party, so both sides needs to be heard. So that means you hear the other party. That is principle of natural justice. I have explained all of these things before, right? Odi alternate partum, and second is nobody can be a judge of their own cases. So there should not be any personal bias in these particular matters. You all must, I don't know whether all you all have followed or not, but in around 2019 or 2021, 2022, what happened was the Krishna water or the Godavari water, the Krishna water, the distribution of Krishna water was there and it came to the Supreme Court. Now, N.V. Ramanna was the Chief Justice of India at that time. N.V. Ramanna, he said, I should not be a part of this bench that judges this case because there is an inherent biasness within me because I come from the state of undivided Andhra Pradesh and I might have certain favor or certain biasness towards Andhra Pradesh that I might not realize. So that means justice should not only be done, justice should be seen to be done. Even though Ramanna would have not put in any biasness in that judgment, still people would have questioned that he might have put in that biasness because he belongs to a state of undivided Andhra Pradesh. Yes, understood? So that is why to remove these personal biases, a particular person should not be the judge of his own case. See, so these are the things. We'll write certain answers now. Okay? We'll discuss certain questions and answers under Unit 1 and 2. Okay. Let's take a 5 minutes break. स्टार्ट करें. No, we'll do this practice in every class from now on because समझ नहीं आएगा. Write a question. First question. Public administration. Public administration is constantly being reinvented. Is constantly being reinvented because it is contextual. Elaborate. Start writing the answer. Mother. Rabe, are you writing an answer? Public administration can be defined in introduction. What was the question? Public administration constantly being reinvented because it is contextual. I mean, you can write an intro regarding this. I mean, it is important actually to introduce it, to define the limits of it or the scope of it. That is how you will explain how uh, it is being reinvented because that scope itself is changing. It's a 10 marker. You only have 7 minutes to write it. Yeah. Write certain brief bodies. Essentially, tell me the points that you will write. Write those points. You can write full sentences later. Okay. Hmm? Now, मैं पढ़ के सुना रहा हूँ. मतलब मेरे को पढ़ा नहीं जा रहा मेरे से. टीपीए एनपीए सही लाइन पे तो लिखे हो, बट क्या क्या है? हम्म. हम्म. जैसे कि टीपीए से एनपीए चेंज हुआ. हम्म. देन Hi. Hmm. Scientific management focus to a welfare state focus. Hmm. Pawan, next. What all points? What is the structure of the answer? Hmm. Public administration is constantly being reinvented because of its contextual nature. What did I? Because it is contextual. हाँ, ठीक है. Elaborate. Hmm. Good, correct introduction. Reinvention of public administration, but differently based on different time periods. See, the idea is fine. That okay, different time periods we divide it, and we see in what time period what exactly was important. Rabe, do you have anything to add? You add and then we'll discuss. कोई स्टैंडर्ड फॉर्मेट है ही नहीं. एग्जामिनर को पता चल जाना चाहिए कि भाई इसको बंदे को आंसर इसने जो लिखा है, जो पूछा है उसने वो लिखा है, कैसे भी लिखा. नहीं, ये सब मिथ है. लोग कहते हैं पॉइंट वाइज लिखो, पैरा वाइज लिखो. ऑल मिथ्स. Basically, you have to answer the question. How you are answering the question, that's your problem. Yes, pandemics, economic crisis require administrative innovation. Yes, yes, of course. Basically, it is saying it is saying administration is not a static activity. It is a dynamic activity, right? So administration being a dynamic activity, it is getting affected by its ecology, ecological approach, Frederick's. Its ecology was very feudal in nature in medieval times. It was feudal in nature. Then it was very industrial in nature when this scientific management came. Then another idea came that socio-economic changes. Yes, Rabe. Another idea after scientific management, we come to a more of a welfare state, welfare-oriented state. That citizens are demanding certain functions. Okay, citizens are uh, demanding certain services from the public. That is why the government or the administration needs to work towards it and deliver those goods and services to citizens. Are you able to understand? So the demand of the citizens change. That is also a context. Contextual means what? Where the administration is working, in what context is it working? That is the very idea of context, right? So contextual nature of public administration. Now, how is this context changing? From industrial state under the classical theorist, there is something called welfare state. So this should be the introduction only. Introduction में इतना हो जाना चाहिए. After welfare, this should start from welfare. Your answer structure or your body should start. That it is contextual in nature. So in the first line, you explain them that administration is not a static activity; it's a dynamic activity. That means providing services and taking care of people. That is the very idea of public administration. Second idea. Second idea is because the nature in or the society or the ecology within which or the environment within which administration operates is changing. That is why administration needs to reinvent itself. Hmm? So what are the instances of these reinvention? From a very business oriented state. This was what this study of administration, Wilson wanted to make administration more business like. So you write Wilson's idea, write this down. Wilson's idea that it wanted to make administration more business like. Yes, administration more business like. That means he wanted administration to be different from politics. That means what? Administration or the concerns of society does not concern the study of public administration. Is it? Is it not what we discussed? That is why new public administration will come, right? Because the study did not care about social issues. Then, before this welfare function, we study something called, so this welfare state will come, and this welfare state will care about people's issues. So, the function of administration is to care about social issues. Yes. Then, what will the next step that will happen? How is the context changing? The welfare state will become bloated in nature. What will happen then? What kind of movements will come? There are two essential words I am looking for now. Correct. But before NPM, what two movements will come in two different countries? Reaganism and Thatcherism. It will come and they'll bring in that the government, which is functioning, it is functioning in a very bloated manner, in a very inefficient manner. We need to make them very streamlined, very efficient in nature. So, from this, ideas such as PCA, public choice approach, and NPM will emerge, having their impact from Thatcherism and Reaganism. How is the context changing? The welfare state was criticized because it was guzzling down a lot of public resources, but it was not able to provide goods and services for that. Then, what is the next step that will happen? How is the context changing? Then the context will be under this. What is the context? Globalization, liberalization, and privatization. This is the context in which things will emerge. Then, what will be the context? Then some ideas such as technology will come, digital governance will come, digitization will come, digital era governance. So now government, rather than being business like, now can be very top down in nature, very hierarchical in nature. So now those post NPM ideas become very much important. If you go ahead and see the PYQs, that is why I was emphasizing the first 3 units. Most of the answers come from those 3 units. Unit 1, Unit 2, Unit 3. In Unit 1, if you have done NPM, post NPM developments, new public administration, those things very well, and good governance very well, you will be able to answer any question in some regard. Because you can use your knowledge in those things and you can apply those in a lot of other answers. Okay? You can see how you are applying that evolution of public administration in this answer. That how public administration is reinventing with changing times. It reinvented itself and made it very welfare oriented when people wanted to solve public administration their problems. When public administration became very big and inefficient, it reinvented and became very lean, very streamlined. When with that problems emerged that you are treating people, citizens as client, public administration became what? It became more and more new public service approach, new Weberian state. good governance. So from that era to digital era governance and good governance, administration has reinvented itself with times. Changing context, administration is reinventing. In a society where centralization is required, or in a situation where centralization is required, administration gets centralized. Where decentralization is required, administration gets decentralized. Can you see from that knowledge of the evolution of public administration, we can answer this question. Okay. Let's discuss the second question. Okay? Are you able to see that this becomes interesting because you all know this? Yes, very. That is the purpose. That even though we are having certain notes with us, it does not mean we'll be able to answer the question. Yes. No, right? So these are all PYQs, okay? And this is on the similar line that I explained. Question number two: the scope of the discipline of public administration. The scope of the discipline of public administration is determined. The scope of the discipline of public administration is determined by what an administrative system does. What an administrative system does. Does it mean that the scope of this discipline is boundaryless? Does it mean that the scope of this, you haven't written? कहाँ से बोल रहा है? Scope of the discipline of public administration is determined by what an administrative system does. Does it mean that the scope of this discipline does it mean that the scope of this discipline is boundaryless? Explain. बताओ क्या लिखा है, एनपीएम में क्या लिखा है? क्वेश्चन क्या पूछ रहा है? हम्म नहीं, एनपीएम तक पहुंचे कैसे? सवाल पूछ क्या रहा है? What is the question asking? Hmm. What does that mean? What are we written? पोस्ट कॉर्ब, हाँ ठीक है, पोस्ट कॉर्ब एंड मतलब what is the I mean what is the question asking and where are you taking this answer? That's what I'm asking. Absolutely yes, correct. Then hmm. Hmm. So the question is asking the scope of the discipline of public administration is determined by what the administrative system does. So what the actions it is taking, what the administration is doing, this is ever increasing, right? That is the logic. It is increasing. Does it mean that the scope of this discipline is boundaryless? The question is asking, it is increasing and a lot of functions are coming, a lot of functions are going. But is it boundaryless? The question is that. So there are two perspectives. Rabe, do you have anything to add? Anything that you have written? Okay. Now you understand the meaning of the question? Question is asking that previously administration used to do this much amount of function. Now administration does this much amount of function. Yes? That means this scope is expanding. Is expanding, right? When this is expanding, what do we experience? That state is taking up more functions. That is the question. That is the statement that is given. It is asking, is this expansion boundaryless? Is there any boundary to this expansion? The answer can be yes, the answer can be no. Answer are both. So we say that this boundary is blurred. This boundary is very blurred in nature. How is that so? How is it blurred in nature? Because there is no definitive boundary. Today it is providing welfare, tomorrow it is regulating, and then the day after it is facilitator. So administrative actions are in public administration functions are increasing. Previously there was no capital market to regulate, but today it regulates the capital market. Previously there was no national green tribunal. Today there is national green tribunal. That means those boundaries are very blurred in nature. What is happening right now is that this boundary has become very blurred. What we need is that we for to study public administration we need a defined boundary. So we say it is blurred because this expansion is happening, new forms of things are taken up. But we also say that it is not boundaryless. There are certain boundaries. Now, what are these boundaries? Do we study what happens inside companies in public administration? How Reliance is functioning, do we study in public administration? In organization, we study how private organization function, but in the study of public administration, what is public administration? It is studying the public functionings of the government, right? For example, private practices or how a particular private company is doing. Do we study that? No. We study private organizational structure, we might study. But do we study how private company is doing the last year? In the last 3 years, how private industries have done? We don't study that. That is, of course, a boundary. So we don't study. For example, we say first point or the first argument, first perspective is it is blurred. Second is there are certain defined boundary also. It is not blurred. It is not boundaryless. It focuses only on activities related to governance. Good. So it is not blurred because we don't study private industries. Yes, certain private parties. Also, we don't study what? We don't study certain functions that government has nothing to do with, certain illegal functions. So there is a black market going on. Certain illegal functions, we don't study those things. Similarly, in public administration, even though there are certain overlapping functions that are there, those overlapping functions with subjects such as economics, law, etc., we study those things. That is what it makes the boundary blur. But there are certain defined things that we don't study. What do we don't study? Private industry we don't study. Certain illegal actions we don't study. Informal actions we don't study. If people are doing something informally, there is no formal mandate of the government, we don't study that. So that means there are certain boundaries that there is with public administration. But mostly because of coming of such as things such as PPP, yes, digital era governance, these things, they broaden the scope of public administration. Scope of public administration means what is the boundary in which we are studying? That boundary is keeping on shifting. Okay. So this is where we say this boundary is not fixed or it is not boundaryless. The boundary is very elastic in nature. There is elasticity, there is flexibility in the boundary. So if there is an elastic, it can go back and forth, but that does not mean that elastic does not exist. Okay, it can accommodate new things. It can let go of old things, but that does not mean there is no boundary. It is elastic in nature. Okay. Now, wide range of activities. Yes. Now next, you understood what question meant, what it was asking, because you have to answer exactly what it is asking, not what you know. What it is asking, you answer, then you will only fetch marks. And this is the purpose of this exercise. We'll do this at least half an hour every day, half an hour, 1 hour. Next question you write. Public administration is the translation of politics. Is the translation of politics into reality that citizens see every day. That citizens see every day. Explain. First, explain me what it means, then write whatever you want to write. It is, but that's not what question is asking. What is the question asking? क्या है क्वेश्चन, क्या पूछ रहा है? हम्म? क्वेश्चन एक बार पढ़ना, क्या लिखा है? हम्म? हम्म? क्या होता है इसको? The question is asking, the public administration is a translation of politics. Whatever politics is determining, whatever policy they are framing, public administration is changing that politics, that means that policy, into reality, into actual tangible change. If the politics is deciding that we want to frame a policy regarding uh, things such as what, nutritional, or things such as women empowerment, administration makes that into reality. That is the question is asking. So write whatever you want. You understand now what it means? written? What all you have written? Give me the body of the answer. What is actually? Hmm? Nothing. I mean that how something, how some policy is actually shifting from paper into reality. This is what it is asking, right? The question was, public administration is the translation of politics into reality that citizens see every day. Now there are two things that administration translates into reality. That there is a particular policy, for example, things such as aspirational district program. Okay? Aspirational district program. So this is the government intention or the intention of the politics or the policymakers. The legislative intention is that we improve the developmental indicators in these what do you say, in these blocks or district which are very backward in nature. Understood? Now that was the purpose. Now administration might do that, might not do that. It might change everything about that policy into reality, or it might not be able to do so. It will fail in doing so. So state what for example, we write first part of the answer, that how administration is the vehicle through which policy elected representatives decide policies based on public mandate, like government promise free education, water, roads. Yes. Huh. So administration is the vehicle through which this becomes a policy becomes reality, but not necessarily this vehicle always delivers. Okay. So the question is asking, the intention of the question is that it changes into reality. How does it change into reality? First question we ask ourselves. How is it changing it into reality? There are certain mechanisms of implementation. There are certain mechanisms to implement of implementation. They're using what? They're using the machinery of the bureaucracy or the district administration to take those policy into ground. These mechanisms are also changing in nature. For example, they are letting private bodies and also PPPs to deliver these goods and services to citizens. So administrative policy or public policy that there is, the politics, whatever is deciding, it is doing what? That public policy administration these days is partnering with citizens, NGOs, private parties, and creating that networked governance to deliver goods and services to people. Okay, so this is how the mechanism actually looks like. Sometimes the administration also fails to do so. Now, what do you call an administration that fails to deliver the policy or is unable to deliver the policy? What kind of a state is that is not able to deliver the policy? Soft state. So this is a counter perspective, right? Not necessarily every time whatever the intent of the legislature is, this thing, whatever the intent of legislature is, not necessarily they go ahead and fulfill it. Yes, not administration has a lot of problems. Okay, what all these problems can arise, such as discretion. Now discretion is given to the administrator to carry out certain policies, carry out the implementation of certain policies. This administrative discretion, if this much amount of discretion is given to carry out certain functions, if they go ahead and do this also, this was not given to them. That means the intention of the policymaker of the politics. Politics is the policymaker. The intention is not necessarily always fulfilled because administrative discretion are misused at times. Maladministration happens at times. Understood? Maladministration happens at times. So these discretionary powers are misused. So it shows, first we answer how administration is the vehicle that delivers reality, and second we answer how not necessarily every time administration delivers. Okay. You are able to understand the question? Okay. Right. Last question. We'll do today. Uh, discuss how the public choice theory promotes the concept of steering and undermines the concept of rowing in visualizing, promotes the concept of steering and undermines the concept of rowing in visualizing efficient efficient and effective administration. Hmm? Concept of rowing in visualizing efficient and effective administration. Done? So what does it say? What is the meaning of the question? What is exactly the question asking? Discuss how public choice theory promotes the concept of steering and undermines the concept of rowing. So, how public choice theory promotes the concept of steering in visualizing efficient and effective administration? First part answer. What all did you write? Hmm. Right? But what is the principal function under steering? It is asking now that public choice theory is saying why steering is better than rowing. So you define steering first. What is steering? टैक्स के ऊपर टैक्स तो नहीं बट somewhat correct. Should be only be done by the government. Rest of the function should be done away with. Why so? What is the reason of doing away with it? Letting the private sector do it? What is the reason for that? Hmm. Give me some keywords. What all you have written? Efficient and effective administration, timely delivery of services, quality and services. These are the outcomes of a steering state. But what is exactly a steering state? You have to define first. Okay. So in this question, PCA approach is promoting what? PCA approach is promoting a kind of government that focuses on steering. Steering means you make certain policies about certain things and you let the private sector take care of it. So your job is on essential functions. So you first see how through steering PCA wants to achieve what do you say? What is the question asking? Effectiveness and efficient and effective administration. How through steering PCA wants to achieve effective and efficient administration. You have broken down into two parts in the question. Okay? First part, how is steering promoting? First, you make a larger policy. Okay, you let the market follow that policy. For example, that Digital Data Protection Act, for example. Okay, so there are no government social media companies, right? There are private companies. But a steering state is doing what? You are making certain laws to regulate the conduct of private sector. Okay, so these acts are certain regulatory functions. These social media intermediaries will go ahead and regulate it. Okay? Similarly, what is the next thing? What exactly? What else is the steering state doing? Public choice approach means what? What is public choice approach saying? Public choice approach is saying that these bureaucrats and politicians, they are self-interested in nature. Yes, the bureaucrats are vote maximizers, and sorry, politicians are vote maximizers, and bureaucrats are budget maximizers. Everybody wants to benefit their own sake. That is why what is required is you want to use this personal ambition, use this personal incentive to promote economic growth. So basically, incentivizing incentivizing personal choices. If there are two choices, that in one choice the administrator is benefiting more economically, so naturally every human will choose that is what public choice approach is assuming. So it is using this procedure or this thought within humans to incentivize that. Okay, so that is that means promoting a rational approach within bureaucratic and political decision making. Yes. Now next, what are they doing with steering? They are acting as a kind of facilitator. Yes, they are letting the public decide what exactly they want. Yes, they are letting the public and the market decide whatever they where they want to go. So policy, rather than being top down, is becoming bottom up. Bottom up policy making is happening. Are you able to understand? From top down, bottom up policy making instead of top down, bottom up policy making is happening. Because of this, what has resulted in is the government is now focused not on delivering the direct goods and services. It is now creating condition in which other agency and non-state actors, as you said, they can deliver goods and services. Secondly, now the second part of the question, why rowing was a problem? Why does it not promote rowing? So second part of the answer will do what? Why rowing is ineffective in nature. Why is rowing ineffective? It leads to bloating of the government. Okay, government is overactive in areas it should be underactive. That Amartya Sen and Jean Dreza's idea. That is how you use those topics under policy making into this answer. Similarly, how is rowing problematic? State inherently, the government functioning inherently are not efficiency bound. They are not focused on efficiency. They're focused more on what? Delivering certain services. Okay. Why is rowing problematic? There is no client focus. Okay. Client focus, private sector, if somebody is a client, the private sector is always consider the client a god. But public sector consider themselves as god. There is a difference. So client orientation is lacking. Similarly, Rowing makes the state very rigid in nature. Why so rigid in nature? Because while doing rowing, because they are the only one providing those goods and services, there are certain monopolizing elements within this. They act as monopolies, monopolizing functions. Understood? Then, what else? Why is rowing problematic? What else have I missed? Something must be there. Read the question again.
Public safety promoted concept of steering and undermine rowing visualizing efficient
Hmm. So why did it undermine rowing? Because of this. Okay? Now, when you write after this, when you write the conclusion of this, you'll have to see that public choice undermined it, and there are problems that started because of this undermining of the state function. Because public choice painted a picture that whatever private does is good, whatever government does is bad. This equating created a problem. What kind of problem is this? What it led to? The problems that happened under NPM was because of this: treating citizens as client. Treating citizens as clients. Don't you think it's a problem? Because citizens are constitution, they have a constitutional existence. Clients are just in a marketplace. Treating governance as a market activity is a problem, because it also overlooks certain functions that certain administrators and certain politicians, they are there to reform things. Administrators such as people like TN Session, E Sridharan, these are people who are there to deliver goods and services, who want to actually reform the way government works. They want to change and they keep public interest at the top. A lot of politicians do that. So public choice approach ignores these attitudes of government. That is why public choice approach is right in pointing out that the state is not working the way it should, but it falters in assuming in all of these things. This should be the conclusion. Okay, so first paragraph, you write introduction, that you write introduction should be nothing but the answer to the question, that the examiner from the first line reading, that examiner should understand that yes, you know the answer to this, you have understood the question. Rest of the answer, that person will see have you covered everything in the answer or not. First line should be pinpoint, that yes, you know the answer. You should not write that, okay, you should not build up something. You shouldn't start a story. You should directly come to the point. And in conclusion, sometimes you can write a counter perspective or a balanced view that why this particular way of thinking is problematic. Understood? Let's end it then. Rabe, did you understand the questions that I explained? Okay, okay.